Yeah, because sometimes there's always argument about, oh, a conveyancer have enough knowledge to cover some of the legal aspect. Why do I need to talk to a
Sure.
professional lawyer in
Yes.
property law? Yeah.
Yeah. I think that the distinction is, and we do help conveyancers in our practice. So I certainly have a lot of experience with conveyancers, and they do their part of the job well, certainly. You are tasking them to run through the process of the conveyance, not necessarily give full and in-depth advice on the development prospects of the particular piece of property. Some conveyancers do have experience in the area, but don't have the legal background necessarily to go through what the consequences are going to be through the rest of the development. They might be able to tell you, say, that a covenant is there, but they're not necessarily going to be able to tell you the likelihood or risks of trying to remove it or vary it. So that's where there's a bit of a crossover. And this goes back to making sure that when you're talking to your lawyer, that you're giving them the scope of what you want. Because, for example, from a cost balancing perspective, you might say, okay, a conveyancer is going to do the actual physical conveyance, but I just need advice on X, Y, Z elements of the property or on particular, say it's the construction contract side of things. Yes, the property is being conveyed by a conveyancer, but the lawyer is now getting involved to deal with the tendering process, to deal with the building contract.
Yeah.
So it's a matter of risk control and preference in some respects, because lawyers or specialists in particular should be able to give you more peace of mind as a developer that, okay, I'm going into this project with my eyes open. I understand the risks that are there. I have factored in the right contingency levels to make sure that those risks are factored in. If the risks don't eventuate, fantastic, you're ahead of the game.
True, so true. I mean, especially with a lot of developers coming from a property investor background, they've always been, mainly dealing with conveyancer in their past transactions, and they think, okay, conveyancer is experienced enough, but somehow, they are dealing with.
Yes. And that's the thing, like you need to know, whether it's a lawyer or a conveyancer for that matter, the background of your service provider. Because someone that's done a whole lot of existing residential purchases and sales for an investor, for example, they're not looking at the same things, whether that's a lawyer or a conveyancer for that matter, they're not looking at the same things that a lawyer who's experienced in development work is looking at. If we, as lawyers, know that you're buying this property to build a particular sort of project, okay, you might be buying 3 side-by-side blocks and you want to construct a small apartment building, for example, the considerations in that and then looking through the planning scheme are different to someone looking at an average suburban block and wanting to divide it into 2 or 3 townhouses. So it's that kind of experience that you're looking at to be saying, okay, am I getting the right sort of advice? Is my professional gelling with the kind of risk and information that I'm after? You got to make sure that your lawyers are focused on the commercial points, what you're trying to achieve, not just the legal situation of a particular property.
Yeah, that's so true. And also from a development perspective, you should always budget those costs, in your feasibility study anyway. So, yes, lawyers might cost a bit more than much more than a conveyancer, but at least it will give you that sort of safeguard in terms of potential litigation.
Yeah. And that's the thing. It's like expending those costs at the start, albeit it's not the best time, obviously, because money's going to come in at the end of the project.
Yeah.
It will be a lot cheaper fixing the issues, or at least knowing about the issues and having strategies in place to deal with them at the start, versus finding it out at the very end and then sort of chasing your tail to try and get it right.
Yeah.
And worst of all, getting into litigation, and we have been doing a lot of, and it's a bit of an insight for your listeners, we have been doing a lot of construction litigation because, especially on development projects, through the last year, it's been obviously very publicized issues with respect to shortages of materials, shortages in people, rapid increases of costs. So there has been a huge amount of friction between developers and builders, and projects that have been substantially delayed, and some builders even walking off sites. And at that point, if you're in the middle of litigation or having to pursue litigation to enforce your rights to get a level of compensation, it's going to make your profits evaporate ultimately. And having considered those issues at the start, those risks at the start, will create pathways for some of those clients that we did do that advice for. It's created other pathways for them to be able to resolve the issues with their builder and reach a commercial position. They're not necessarily going back to absolutely square one, what would be the developer's ideal position, of course, because the problems have arisen, the world market is what it is. But because of the rights that are there, it's given them enough leverage to be able to reach a fair deal.
Okay, that's an eye opener. I mean, sometimes it's good to have those extra clauses in the contract in case something bad can happen, and then at least you got some leverage to get back.
Yes, exactly. It's the leverage. It's the leverage that's the key, because you are not necessarily going to want to engage in commercial litigation. You head into the Supreme Court and you will be up for, many tens of thousands or hundreds of thousands of dollars of legal costs. To what benefit ultimately if you could have had those issues addressed at the start when people's relationships were much better, and to at least create the pathways to give you enough leverage if relationships deteriorate, to be able to at least get it a little bit more your way.
So true. Okay. So if you were to go back to teach to yourself, younger self, or teach to your kids, what would you teach them?
I think in terms of lawyers' perspective and a service provider generally, it's to be focused on your customer, to be focused on the person you're providing the service to, and to understand what they are trying to get out of the transaction, trying to get out of the particular matter that you're dealing with. It's not about the technical ins and outs of whatever is the task. It's actually what the end goal is, and make sure always to be practical in the resolutions. Don't just think about, okay, it's a mathematical equation here. It's like you're trying to work this out. What are the different mathematical ways you're going to get to a result? It's not that. Ultimately, it's a human situation. Whether it's the client that you're working for or the other party, you've got to look at that people element and to focus on the practicalities. You want to deliver a practical result, and people will appreciate the practical result more than the technically legal one per se, because the technically legal one may well be the long way around, the more expensive way around. Yes, formally correct, yes, but not practical in terms of achieving what the developer, the customer, actually wants.
So it's a bit of a compromise between the litigant and the client, and so
understand the balance. Litigation, like looking at a dispute as a good example of that. Certainly, at the very start of any dispute, your client will always be wanting to be as aggressive as possible, going into court, having that fight, because they feel like they have been wronged. The other side has done the wrong thing by them. How can they get away with this? It's a point of principle. But the reality of that, as an experienced lawyer, is to be saying to them, yes, we understand that you've been wronged and that the other side have done a bad thing to you. But now you're really in this situation already. There's already a negative impact on you. How do we get out of this situation in the best way possible, limiting your cost and loss, and still enabling the project, the actual focus of what you're doing in the first place, to continue? And sometimes it takes a little bit of time for people to understand that, and the process has to continue. And sometimes you do have to be aggressive on the litigation process to give yourself the leverage. But it's always important to have that end point in mind and not just keep blindly running through the process because it's process. You want to be focused all the time, and to keep the client focused all the time on what's the best outcome for them. And even though, okay, it might be very annoying that the party that's done the wrong thing might, from some perspectives, be getting away with it, in inverted commas, it still will be the best result at the end of the day, once you know the client's already in this hole.
So that would be a discussion between, like lawyers and lawyers representing their specific client. Yeah,
it's to be, and to be, for your own client, to be transparent about the fact. With the other party, it's about being, and the other lawyer, it's about being, I guess, very careful and use your judgment as to Sometimes it's sensible to share this information because you both are on the same page about trying to get the best outcome and negotiate a way through. Sometimes in the more aggressive parts of the proceedings, it's better to have everything close to your chest, basically, and just be very aggressive because you're trying to gain that leverage. So these are all tactics this is why you ultimately retain an experienced lawyer if you're in a dispute situation, to be getting that insight, to be going, okay, this is the right time to hold back, and this is the right time to share, and let's get a practical solution.
So it's sort of a high intense negotiation type discussion between those two lawyers and see what is the best outcome for both.
Exactly. And going back to the question in terms of what you would be telling my younger self, it's to be to know in that situation that you've got to focus on what the customer's intent is on the overall project, and then to be laying out your cards in the best way, whether that's being aggressive or sharing in terms of trying to achieve an outcome, laying out your cards in the right order to get that outcome at the end of the day. There are times when you have to be procedural and hold everything back because it's gaining your leverage. And there are other times when you want to be sharing and trying to make the other side almost feel like the other lawyer, that you're almost on the same side trying to get this deal in place. It's trying to get that balance. It's people management at the end of the day.
It is. It's also about, trying to build that sort of relationship and see, okay, how can we get this to work without going through court and all those high costs?
Yeah, absolutely.